Welcome, everybody, to Diversion Insights. My guest today is Judge Jose Salinas. He is a judge at Marion Superior Court in Indiana. I want to thank you so much, Judge Salinas, for your time and welcome you to the podcast.
It's my pleasure. Thank you so much for the invitation.
Absolutely. We're going to talk about what you are seeing in your courts, specifically with those with a substance abuse disorder and how you are utilizing drug court successfully. So let's start first with having you tell us a little bit about your career and the path that you took that brought you to Superior Court.
Okay. Well, I'm originally from South Texas, and we used to come in the summers to come work in the Midwest. So I have a lot of family in the Midwest. We stayed here over time. Graduated from Indiana University Law School in 1997. I hung up my shingle here in Indianapolis, which is the capital of Indiana, right in the center of the state. And I was lawyered for about 10 years. Got elected the first time in 2006, reelected in 2012, again in 18. I'm up again this year. And so I've been on the bench going on 17 and a half years. So 10 years as a lawyer and 17 plus as a judicial officer. And I've been in all that time, all but about the first 4 months, I have been the presiding judge for the Marion County Superior Court 23 and the Marion County Drug Treatment Court, as well as the Marion County Reentry Court. Those are two separate problem-solving courts that we operate here in Marion County.
Okay, great. Yeah. So for everybody voting out there, he's got a lot of experience in this particular arena.
I can't. We're on a retention vote, so I'm not advocating for that.
Okay. All right. And, scratch that.
but if you vote yes, great. If not, well, that's fine.
Okay. Sounds good. All right. So what types of cases do you see in your courtroom? Do you have an estimate of how many people that come through have some sort of substance use disorder?
Well, in my courtroom, and let me explain for our listeners here. The problem-solving court is a different dynamics than what you see like on TV, like in Law and Order. We call that kind of court, like what you see in TV, our adversarial court. That's when you have the lawyers going in and yelling objection, overrule, things of that nature. The problem-solving court is a little bit different animal. It's a little bit more at ease. We still follow the rules of evidence, but they're more lax because we want to get to the heart of the issue. So as far as the problem-solving court, the drug treatment court, everyone in our program has to have a link and or a substance abuse issue. That is the nexus to get into our program. Now, in the adversarial court, which we handle DUIs, batteries, drug charges. I would say more than half of the cases that we see have either a direct connection to substance abuse or drugs, such as DUIs or possession of marijuana or some other substance, or it's either a theft and they're stealing to fund their habit, you know what I mean? So on the adversarial side, and this is all my own numbers, but this is from what I see in my court. On the adversarial side, I would say about 60% of the clients that we see have some kind of nexus to substance abuse in some way. On the drug treatment side, which is our problem-solving court, 100% of those clients have a nexus or an issue with the substance abuse because they have to be allowed into our program. And our program there's two unique facets to it. One, it's pre-plea, which means if you're admitted into the program and you graduate our program, your case gets dismissed by the prosecutor, which we're very proud about that. And the second aspect is it's strictly, you have to volunteer to be in the program. You have to want to be in the program. You're not assigned to it. You're not ordered to it by a judge. And that's unique because our requirements in our program are 10 times harder than what you would get in the adversarial court if you were to be sentenced to, say, a regular probation docket. The requirements that we have, and I'll be happy to explain those during the course of our conversation, are a lot harder. We have more requirements from our clients.
Okay. Yeah, let's definitely talk about that. So just for my clarification then, is drug court synonymous with problem-solving court? Or
yes, problem-solving court is the whole umbrella. Under that, you have reentry court, which is people coming out of DOC. We have drug treatment courts like mine. You have DUI courts. You have family-based courts as well. There's various problem-solving courts, but they all have a couple of unique features that are different than the adversarial court that you normally would see on TV. And it's those unique features that stand out when you come see our court.
Okay. And does anyone with going through adversarial court ever end up in drug court, or that's completely separate?
No, they do, because once you go, first thing, once you get arrested, you get charged with whatever charge you end up with. Then your lawyer will look at the case. If they feel that you are a better candidate for drug treatment court, then they can apply for you to be in our program. Now we have some aspects of that I'm not really happy with, which means, and by that I mean, most attorneys don't apply for our court until they're 8 or 9 months on down the process, because they want to explore all the evidentiary avenues that the case may have. We always feel that if you're an addict, the sooner you get into our program, the better. Sure. But even 8 or 9 months on down the process, if you're an addict, you're still an addict when you come into our program. That's not going to change, because it's hard to overcome that addiction. So while we would like to get clients, and we call them clients, we don't call them defendants in the problem-solving court arena. We would like to get our clients within the first 90 days. That would be ideal. Very rarely does that happen. Normally we get them within 8 or 9 months on down the process.
Okay. All right. So you allowed me to sit in on the drug court so I could see how it works, which obviously you see I still have some questions even after doing that.
It's a different animal. Oh my God.
Yeah, it really is. And I just want to share with the listeners some of the things that I observed. So first and jump in anytime if I'm, not saying something correct here or misrepresenting, but first there was a morning session and the client was not present for that. That is called
staffing. That is when the same players are in both adversarial and the problem-solving court arena, which means we have a judicial officer, we have a defense attorney, and the prosecutor. What is different in the problem-solving court arena, we also have case managers that are in our meeting. We call it staffing. And we also have the treatment providers as well. So that morning session, it was strictly off the record. It was not on the record. It's a meeting that we do virtually now. We used to do it in my office before the pandemic. Now, with the pandemic, that we all we're all more
got used to virtual.
The virtual meetings. We do it virtually now. But in that meeting is the prosecutor, defense attorney, the case managers, and the treatment providers. What we do in that meeting is discuss how our clients have done the last 7 days or since their last court session.
Okay. Yeah. And you also, I think, had drug lab there, right?
The lab is there as well, because many times there's always nuances to whether something can become positive or not, whether it could be a false positive. And I'm always amazed as to the new types either of questions that come up in terms of could that cause a false positive? Yeah. And I'm also amazed at the way clients sometimes try to deviate from giving us a valid sample.
Yeah. So there was an interesting one the day that I was there. I believe it was ibuprofen. They were attributing something to ibuprofen. And you asked for whatever the next step is with the lab.
Yeah. We do a confirmation if they're disputing that it is an accurate positive results. They can ask for a confirmation. And that is their right within our program. Over the time, I've come to realize that if it's about 50 times it is, maybe, no, hang on, let me rephrase that. But 1 out of every 10 times it comes back a false positive in the client's favor. The rest is usually a reason why. And I always tell the defense attorney, it'd be nice if the clients were to at least let us know, because the only way we're going to be able to help them effectively is to let us know what's going on in their lives. Because the first thing we do when we have a positive we ask them to look at their day. What if they do differently? If they're saying it's a false positive, did you eat something out of the ordinary? Did you take some medication that you weren't supposed to? That's what we always tell our clients. Look at what you're putting in your body. We have a list that we give our clients when they enter into our program of the medication that they cannot take. And all this is over-the-counter stuff, because the ones that are prescribed, those are things that for sure you can't take unless the doctor says it is medically necessary for this patient to take this drug in order to maintain the health that the doctor would want.
Okay. Have you had anyone use that list to then try to game the system and say, oops,
all the time. Well, we always, because there are always new things. I think the big one now is vaping, Well, I didn't know that. I mean, because it's weird. In Indiana, we allow hemp, to be in products, but we don't allow marijuana is still illegal. So they say a very small percentage of marijuana is in vaping products. We do have a cutoff limit as far as if you're over a product or over a certain limit, then we consider it to be actual marijuana use. And so the debate is, and listen, I understand it from my clients. So our clients will say, if it's against the rules, why is it legal? If hemp is going to cause a false positive for marijuana, why is it allowed in Indiana? And sometimes I don't have a good answer. And another geographical dilemma that we face in Indiana is every state around us, Illinois, Michigan, Ohio, Kentucky, they all allow marijuana in some form or fashion, either medical marijuana or just outright, marijuana. Yeah. And so, we have that to overcome in our process. And so we have evolved over time. Just to say it on the marijuana front, I firmly believe that it is a gateway drug, but I will have 10 people, experts, tell me that it's not. Okay.
Yeah.
My belief is grounded in what I've seen since 1991 when I started as a probation officer. Because I do believe that you will eventually get tired of that high and you're going to switch to something else. But experts tell me that it is not a gateway drug, but we all have a right to have our own opinion about these things.
Well, I mean, if you have a substance use disorder, it's just plain and simple not a good idea to be using marijuana. That's a substance. I mean, that can create a problem.
So what we're fighting now is the vaping. The other thing we're fighting what our clients can buy in stores, these designer drugs that are, and even the state statutes are having a hard time keeping up with them because you change one chemical compound, all of a sudden it's no longer illegal, it's legal.
Right.
And so
but for their treatment program, they're still chasing a high. So that's the problem.
That's the whole thing. And it's just, is it a legal high or is it not? Now, the other thing, the other twist in this is when I first started in this program, abstinence was abstinence. You are not, when you graduate our program, you have to be free from all drugs, no matter what. Over the course of time, I've come to be converted into the MAT program, the medically assisted treatment programs, which means we do allow our clients to graduate our program if they're on certain types of medically assisted programs that is approved by a doctor. Suboxone comes to mind. And that was a big adjustment for me, okay? Because I grew up in this program thinking abstinence was abstinence. That's what it meant.
Right. Yeah.
So we do have to evolve as a treatment program, just like we have to evolve as a court system when these things come and are introduced into the community.
Sure. Okay. In that meeting was also your person monitoring the GPS.
Yes.
Which was interesting. Yeah, they had to chime in a few times about where somebody was. And, I found the discussion that you guys all had, seemed complete. It was honest. You really did kind of evaluate the person as a person, where they are on their journey, what else they have going on in their life. Some of them had, a couple of deaths or, something that had happened in their own personal medical history. And so you took all of that into consideration when you looked at what they have done or not done since the last time they were in court. And then you came up with, okay, what are the next steps? Is there going to be that just reward, or is there some sort of sanction that needs to be imposed? But it was a very comprehensive conversation that you all had.
Well, we do get a report right before the meeting starts, and we classify our clients into certain groups: the good group, the fair group, and the poor group. If you've done everything you were supposed to do, you take your drops, you go to your meetings, and you keep.
Let me clarify for people: your drops are drug tests.
Urine drops. Yes, my
Urine tests,
apologies.
okay.
Urine drops.
Yeah, no, that's okay.
And one of the unique facets about our program is we drug test our clients twice a week minimum, sometimes more. In probation, you'll get drug tested once a month if you're lucky.
Okay.
And so that's the aspect of that's the trust but verify aspect of our program is taking the urine drops. So we get a report and we classify our clients into the good group, fair group, and poor group. If you had a good week and did everything you had to do, you're in the good group, and we can discuss what happens in the courtroom later on in our talk. If you had one or two hiccups and they weren't major, like you didn't come, you missed a drop, but it's because you were late for work or you got off late, then we'd probably put you in the fair group. If you really did not have a good week, you missed drops or you came back dirty, and dirty means you came back positive for a substance. I apologize. Okay. On a urine test, then you would probably be in the poor group. And like you said, sanctions or rewards. We do have a sanction and reward basis for which group you're in. The rewards that we have, we administer in court. It can be from candy to a standing ovation to we have now, for the last 2 years, we've had Wheel of Fortune, spin the wheel. And our clients really like that. They have things on there like a standing ovation, get extra candy. We do have $25 Kroger card. We have free parking because in our courts, in our building, we have free parking for the public, but it's like it's a distance away. If you want closer car parking, so you don't have to walk as fast or as far, it is paid parking. So we do have that as a reward, and that's on the wheel if they spin and get on that. But one of the things I really like about our clients, for those in the good group, if they're not in the good group and they believe they are, they want to know why. So our clients have to be our clients have to be invested in the program. Okay, and once they get invested, they want to know, and they're proud of themselves for being in the good group. Just like they're unhappy with themselves when they're not in the good group. I've been told on more than one occasion by case managers or in defense attorneys that the clients really do not want to face the judge when they've had a bad week. Sure. And conversely, they want to be before the judge when they've had a good week, because it may be the only time they've been acknowledged that they've done well that week. Right. And I can't imagine going through life like that, not having someone tell you good job. That very rarely happening. So we do, like, not to get ahead of myself, we do classify our clients in 3 different groups, and our discussions and our staffing in our meeting is based on where they are, which group they're in their group, which group they're in depends on how they've done in the last 7 days.
Yeah, and the whole group kind of has a say, and you were very good about, do you agree? Should we, do this? And so it was kind of a collective group thing, for sure. So then in the afternoon, the clients come to court. Yes. And you then call them up one at a time, and you kind of go over things in general. It moves pretty quickly. There's not a ton of time with each person, but I will say that there was a ton of encouragement. Even when you gave them a sanction of some sort and kind of talked it through with them, you were still very encouraging to them. Don't quit, keep going. I understand, little step back, but let's keep going. And you were very client specific. I mean, you seem to know their circumstances, their struggles. You celebrated and empathized with them while still holding them accountable. And so, we talked about those rewards and the fist pump with the judge, and
that's good about that,
and free parking and stuff. So, I mean, there was one at least that thanked you for allowing them to participate in this program. There was one client that had been struggling a bit, and you asked them, hey, what's going on? And they responded, it's like the quote of the day, nothing that's out of the ordinary. It's like, that just kind of sums up their daily struggles.
Well, one of the things that's unique about the court aspect of the program is we're a little bit laid back. We do have deputies in there. We have decorum, but We allow kids in the courtroom because many times our clients can't don't have money for babysitters or they can't find them. So we do allow kids in the program. We allow family support in there as well. We do bring them up to the bench in the order in the groups. All the group. If you're in the good group, you go first. If you won a first in line on the wheel, then you get to be called first. Absent that, we go alphabetically. The other thing you mentioned, sometimes I don't have interact much with our clients, especially if they're in the good group because they've had a good week.
Yeah.
It's kind of weird because we have a national conference that says ideally the judge should spend 2 to 3 minutes per client. Well, sometimes we have about 40 clients and it's just not feasible. And if you've had a good group or a client in the good group, they've done everything well. You want to save the court time for those that need that discussion, that need either the extra encouragement, and you do. But I always try to ask those in the good group. I always ask the case managers. At least I try to. Is there anything specific I should encourage them or acknowledge this week on this client? That they have something good other than doing everything they should. Did they do anything go above and beyond? And if they did that, then I will acknowledge that as well. But we do want to move our clients along, or the court session along, because we have at any given time 20 to 30 clients that we have to see. Our case managers are multitasking. They're talking, checking in clients, seeing their clients. Sometimes our clients have last minute requests, last minute issues that come up. So it is a fast moving pace. Yeah. We do allow the clients to come up to the bench normally in an adversarial setting. The clients are at the defense table or with the prosecutor. They come up to the bench, and we also allow clients to be there remotely as well. That's one of the new aspects that we got from the pandemic is we like to be open, and we use that as a reward session as well. If you're in the good group and you get a remote spin, you want to be remote, that's fine, because it is a hassle getting all of your stuff together and coming to court and stuff. And if you can do it on your 15-minute break, more power to you. So we incorporate in the session. I'm very proud of the fact that we have the in-person session, obviously, and we incorporate the virtual, the remote part of it as well as best we can into the court session. So I do try to acknowledge each client, maybe, but I do want to spend more time on those clients that have not had a good week, maybe ascertain why they haven't had a good week. If it's something personal, I don't want to put that on the record because it is on the record or it's out in public. If it's something delicate, I for sure don't want to put that on the record. Sometimes they just want to share that with their case managers or their lawyers, and the case manager may share it in our meeting. But they'll tell me, Judge, I would prefer the client would prefer that not be said in court. That's fine. We don't want to mess anyone up.
Right. Yeah, that's true. I saw all of that. It clipped along, but I didn't feel that it was rushed or that anybody wasn't given the chance to say what they needed to say. And you're right, in that initial morning meeting, there were some of those personal things, but you didn't talk to them about it. You just encouraged them in a general way. Maybe acknowledged that, there were things going on you were aware of, but, good for you. So yeah, everything I saw is the system really thinks of the end result, right? And that is that recovery from that addiction, and then keeping them on the straight and narrow after that with, why ever they ended up in court in the first place, right? To not do that again. So I thought it was great. What criteria do you use to evaluate whether you're going to offer this option of drug court to someone?
Well, the first one is the prosecutor. They are the gatekeepers because they're going to be dismissing the case once and if a person completes our program and graduates. So they've been very accommodating to the kind of cases that we want. The ones that we normally do not take are violent offenses, murders, rape. We don't take dealing offenses. We do take high-level possession offenses, but no dealing offenses. Now, the prosecutor has been more open to that, but I understand because they have to run for re-election as well. So the prosecutor is the gatekeeper, and in consultation with us, we come up with the type of cases that we want to have and see in our program. The main thing is you have to have addiction in there somewhere. And the unique thing about this is, again, if you complete our program, your case is dismissed. There's a lot of problem-solving courts around the country and in Indiana that are probation-based. In other words, the judge will order you into the problem-solving court arena. And so once you complete that, you may terminate your probation early, but you still have a conviction on your record. And you may get that expunged in 2 or 3 years, or maybe earlier if that's by agreement of the parties. But in our program, I've always liked the fact that we are pre-plea. Our cases get dismissed once you complete our program. We are technically a 1-year program with 3 phases: phase 1, 2, and 3, 4 months in each phase. But I'm going to tell you that the percentage of people that complete a program in 1 year is probably around 10%. Oh. As you can imagine, it is a struggle. Mm-hmm. We've had clients that intentionally sabotage themselves the week of graduation because they're just scared to be on their own. Wow. They're scared not to have that safety net of the case manager calling them, "Hey, how you doing today?" Having that court meeting, to go to. The text from the drug lab saying you have a drug test today or you don't have one today. So we've had clients sabotage themselves literally the week of graduation because they were just scared. And so the average length of time is anywhere between 18 months to 2 months or to 2 years in our program. It's not unusual for that. If you graduate within the 1 year time frame, it is rare and very much appreciated because we do want to have our clients healthy and happy going forward.
Yeah. Interesting point about the sabotage. Do you folks have programs that you support, programs that you recommend them to get into after to help keep them accountable on some level?
Well, I wish I could tell you that we have a robust aftercare program, but we don't, because in order to be in our court, you have to have a criminal case pending, right? So once you graduate our program and the prosecutor dismissed the case, we lose jurisdiction over you. Sure. So that's why when you are at graduation, there's certain things that we require. One, we require at a minimum 90 to 120 days of abstinence from whatever drug or from all drugs. 2, that you are have paid something on the fees that are assessed and have been in a treatment program actively during all that time in that last phase. And we do want a letter of graduation from the provider. And if you are in an MAT program, a medically assisted program, from the provider and from the doctor as well. Now, you cannot always guarantee success. Mm-hmm. We've had horrific consequences with clients very near within a month of them graduating. And we always go back and self-reflect. Did we miss something? And you can't do that because, they have to want it. And some people are just good at doing what they got to do while they're mandated by a court system. Sure. We've had clients run from our program from a treatment provider 3 or 4 times. And that's another adjustment I used to have that I have had over the time I've been in this program. It took me a while to get used to the fact that people are going to leave a treatment program 3 or 4 times, maybe 4 or 5 times before it actually kicks in their brain that they're trying to help them, that they need this program. So this process has been adjustment for clients, for the program, and for the people that are trying to help the clients, the judge, the prosecutor, the defense attorney, the case manager. So we've all had to evolve over time in the changing environment of the program and in finding the right candidates for our program.
Sure. Yeah. You might not know this because, as you said, once they're out of your program, you lose jurisdiction over them. So you maybe wouldn't know unless you saw them return to court. Do you have any idea what the success rate is?
Yeah, I'll have to get that to you. But don't quote me on this, I think we were at like 35% of our clients. This was a couple of years ago, maybe 6, 7, 8 years ago, when we usually don't have all the funds we use for our clients. So
Sure.
when the local school system, university wants to do an assessment for free, we say, hey, come on in and do it, right?
For sure.
I think we're at 35%. We're above the national average of people that came back into our program within 2 or 3 years. There was some nuances to that, like maybe they got rearrested for a driving without a license. I would consider that to be.
Yeah, they're still in recovery. If they're still in recovery,
So one of the things that we did change, because we were getting so many clients getting these driving without suspended, driving without a license, is we now have a contract with the local legal aid society to help our clients get licenses as well.
Okay.
So so we're trying.
Yeah, you're trying. You really are trying to make their life better and to change their trajectory with what you're doing. Definitely. How many healthcare professionals do you see come through there?
Well, that's the unique thing about this program is when I started as overseeing this court 16 and a half years ago, 17 years ago, it was geared toward professionals. It was geared toward that one person who had that one charge, and if the charge didn't get dismissed, then they were going to lose their license. They were going to lose their livelihood, and so that was our target audience. Over time, the target audience has become the addict, the person with 4 or 5 or 8 or 9 cases pending. Okay. And so that person, the professional with only one case who may have had a problem for 6, 7, 8 months, but is not the long-term addict, we've lost that in the system because this program, we call those low-need clients, not high-need clients. And we're not supposed to mix the need clients together. We don't want the low need people mixing in with the high need people because they see different people they see in their lives personally, right? And so we don't want them mixing up. So we've had to come up with different programs for that that professional because I didn't want to lose the opportunity for them to get their case dismissed.
Right. Yeah. Interesting term, low needs. I mean, it's the same, substance use disorder. Same. So they, need the same type of thing. But there are recovery programs and stuff out there.
Yeah. And then the other aspect, like nurses, we've had quite a few, and we have had quite a few nurses and have 1 or 2 right now. The other thing is we had to come to work over time with the nursing board, the state, because what good is it if you get your case dismissed if they don't acknowledge what you've done here, and they're still going to yank your license? I can understand other people's perspective, right? The nursing boards. I can understand saying, listen, we got to be careful. Yeah. We can't have someone who has had an issue with drug abuse in the past treating people. I get that, and so I understand that they have to monitor separately. To abide by their rules. Over time, they've come to understand that we're on the same team. We're fighting for the same cause. Get this person clean, and we help them stay clean. And so we've got more cooperation from the state boards on nursing, and more recently than we have, say, years ago.
That's great. That's good. Are there some people who are in opposition to drug courts? And if so, what is their main argument?
Well, we are known as the touchy-feely court, okay, within my jurisdiction here. And I can say the opposition was more back when it started in the 90s and the early 2000s, why are we treating people like this? And are you making a difference? Are you making a difference in the community? And my answer is, and this is going to be blunt, my program is not making a difference in the Indianapolis community. And here's my rationale. We see 90 clients. That's it. This town is over 850,000 people. You want me to make a difference probation sees 7,000 people, right? But they drug test once a month. If you get caught being drug tested once a month, you're not a very good addict. Okay. That's just,
do they know when those drug tests are going to happen?
well, no, but if you get drug tested within the first week and they're testing you once a month, you got at least 21 days free.
That's true. That's
and
true.
So
yeah.
where we are making a difference is within the drug treatment community. Within those 90 to 120 people, 150 that we see and graduate, we're making a difference within that community. Now, if you were to multiply our program to the level that probation has, I would say we would make a tremendous impact in the community. The problem is we are a high need program. In other words, our clients are high need. Probation can see anywhere, one single probation officer can see anywhere between 70 to 100 clients, because their job is just to make sure you're doing what the judge tells you to do. Our case managers, their job is to help you do what the judge asks you to do. And so our case managers are limited to 30 clients per manager. So if you were to replicate our program to the levels that we do in probation, I am confident that we would make a tremendous difference in our community. As it is now, we're making a difference within the drug treatment community, that hardcore community.
Absolutely. Do you have a client success story that you can share, something that kind of sticks out as to how you guys really made a difference for someone?
We've had clients that have graduated and then go into the treatment profession themselves. So that's always nice. Another thing I'm proud of, I've had, I think, over about 30 drug-free babies in the 17 plus years that I've been in this. And for me, that makes an impact, because I've been to conferences where they show videos of babies born addicted to fentanyl or some other substance. And it is a hard video to watch.
Yeah.
And so when you, the first thing I ask when clients are pregnant, when they have their baby, is, was the baby clean? That's it. Mm-hmm. And we have another rule. If you're pregnant in our program, you go from being tested twice a week to 3 times a week. Because, we have another life to consider. So the success stories are those stories that we've had clients come back and say, thank you. They're maintaining their jobs and stuff. They got families. And I've run into clients on the street and they say, you were my drug court judge, and thank you. But the one that stands out have been the ones that are now in treatment places as counselors. Yeah. And I think those are the ones that stand out as well.
Right. Absolutely. Well, this is great. I want to thank you not only for your time today, but for letting me sit in on court and really just kind of see what it's about. I really, really appreciate that, and the time and energy that you've given to me, and then this conversation so our listeners can hear about it. It's not something I'm very familiar with, certainly in my role and what I do. And I think a lot of the listeners are probably in the same spot. So it's really good to hear this perspective and to hear what's going on.
Well, I do appreciate the ability or the opportunity to be here. Again, we're based in Indianapolis, Indiana, Marion County. I'm Jose Salinas. I'm the presiding judge for Marion County Superior Court 23 and the drug treatment and reentry courts. If I want to leave your audience with one message, is drug treatment works. It is not for everyone. The requirements are harder than regular probation, but it works. And if as a community you invest in a court system to have this initiative, your community will be better for it, and that I am confident of.
Thank you. That's great. All right. Thank you, Judge, very much for your time.
Take care. Be safe.
Thank you. You too.